This DVD is made possible by a grant from the Virginia Law Foundation and the Virginia Department of Social Services Access and Visitation Grant.
When two or more people are in the middle of a dispute, they often have difficulty discussing the issues openly and productively. Sometimes their conflict escalates and the problems can worsen. They may turn to the courts to resolve their dispute for them. Lawsuits in court usually produce a winner and a loser. Sometimes no one really wins. Litigation can be frustrating, stressful, time-consuming, and expensive. However, there is an alternative. Mediation allows people to take control of their own disputes. It provides them with the opportunity to find solutions that may benefit everyone involved.
I run a small business, and we had a dispute with a customer, and we couldn't solve it. We tried for a year. We couldn't find any resolution until we went for mediation.
Well, as a manager, I have been in work sites where we had many teams of different kinds of personalities. I believe very strongly in mediation because when people are working together, there will be conflict.
If I showed you the responses from my clients that we see in our office, they find this to be a very wonderful alternative to the court system. It is relaxed, it's in a family atmosphere, confidential. They feel like they have an opportunity to really say things to each other that they need to say.
Mediated agreements in complex cases saves judicial resources, saves attorney time, and saves the client's money.
People have more control of their dispute. They have more voice in the outcome. They also are generally much more satisfied with the outcome. They come to a conclusion that they can better live with.
Mediation is not litigation, it is not arbitration, and it is not therapy. Mediation is voluntary, informal, confidential, and you create the solution. It is a non-adversarial, collaborative process that can save time, money, and relationships. Mediation provides parties the opportunity to meet their underlying needs and interests. In mediation, those having a dispute meet with a trained, impartial mediator and describe the conflict from their perspective. The mediator listens without bias, then clarifies the issues and helps the parties to better understand the situation. The mediator assists the parties to communicate effectively and generate creative solutions so that they can reach a mutually acceptable agreement. Mediation can help people in a variety of situations. Family conflicts including estate issues, adult guardianship, elder issues, parent-teen conflicts, custody, visitation, child support, parenting plans, spousal support, property settlement, workplace disputes, EEO, insurance and liability, real estate, education, business disagreements, consumer merchant, contract disputes, landlord-tenant, neighborhood, and public disputes, just to name a few. You understand your dispute better than anyone. In mediation, you can raise concerns and details that a court may not be able to consider. Avoid the uncertainties of trial. Take advantage of mediation to produce better, faster results that are right for you. Mediation is a flexible and practical process responding to the parties' needs. Although there are no rigid rules, generally there are some common elements to the mediation process.
Mediation gets people talking. And again, it doesn't really make any difference what type of case it is because they're all fact specific. Each case has its own unique set of facts. But the thing about mediation is they bring those facts out. They allow people to look each other in the eye, face to face, and say, this is why I am unhappy.
Best part is you hear things, I think, a lot that you had no idea they were even thinking because they never said it to you, because basically while you're sitting and talking to somebody, you're thinking of what you're going to say next and not what they're going to say. And so mediation causes you to listen more to what they're going to say.
Literally, what can happen is you can sit at a conference room table, and for example, if it's a construction case, you can have 6 or 8 people looking at a drawing, talking off the record, no court reporter present, and talking about the issues. That may bring one party or the other to realize this is how this arose. This is the other party's perspective. That can help you resolve it.
It helped me a lot because I like the informal setting. You know, courtrooms are so intimidating. And this way, we worked out our problem ourselves without a judge telling us what to do.
In litigated cases, the judge reaches a required result based on law. In mediated cases, the litigants reach their desired result based on a process that they control.
First, the mediator will describe the process and everyone's role. Then the mediator will ask each of the participants to describe their view of the dispute and what they may want to accomplish. This allows the parties to speak candidly and to express their views in a safe, controlled environment. The mediator then assists the parties to identify the main issues in their dispute, helping the parties understand one another's interests and needs with respect to each issue. The mediator will encourage the parties to become problem solvers, to look objectively at the issues, identify common ground, and discuss possible solutions. At times, a mediator may use a technique called caucus, in which the mediator meets with each party separately and in confidence. This can lead to more complete revelation of the parties' needs and the development of options for a solution. Once the parties have reached an agreement, the mediator or the parties' attorneys may record the terms of agreement. When the mediator prepares the agreement, the mediator will encourage the parties to have an independent attorney review the agreement, since the agreement may affect the parties' legal rights. Although participants in mediation are not required to have attorneys, the process is often most effective when parties have consulted with their own attorney, so that they will make an informed decision on how to resolve their dispute. A signed agreement may be enforceable as a contract. If a case is pending in court, it can be presented to the court as part of the settlement of the dispute. The agreement can be entered as a court order by the judge, thereby concluding the case.
The hallmark of mediation, I think, is the fact that it is self-determination. We are not like a judge. We are not going to decide for you, what the outcome of the situation is going to be. We are going to help you find out what you think the best outcome is. After all, it's your life.
When you go to select a mediator, it's your individual choice. It's who you feel you'll be comfortable with.
Mediators then become facilitators, trying to work people around to see if there is a way to resolve this.
What we do is we give people hope that they can resolve this issue in a way that everybody can come out with a win-win situation, and I can't think of a better process than that.
The mediator acts as a facilitator, not an advocate, judge, jury, counselor, or therapist. Instead, the mediator is an impartial person trained specifically in dispute resolution skills and techniques. As a facilitator, the mediator assists parties in identifying the issues, reduces the obstacles to communication, helps explore alternatives, and moves the parties toward a voluntary agreement. Many mediators are professionals in other areas, such as business, law, social work, counseling, or education. However, in their role as mediator, professionals do not give legal advice or any other professional advice. Where parties need such advice, the mediator may suggest that they seek out an attorney, financial advisor, or other professional. The Judicial Council of Virginia has a certification process for mediators who have achieved a sufficient level of training and experience. There are a number of questions you should consider in selecting a mediator. Does the mediator have experience handling disputes like yours? Is the mediator familiar with the subject matter of your dispute? What is the mediator's style and approach to mediation? Does the mediator primarily facilitate communication, problem solving, and decision making between the parties? Does the mediator help the parties evaluate the strengths and weaknesses of their case? How should the parties prepare for the mediation? How much time should the mediation take? How much will the mediation cost? In some courts, there may be free or low-cost mediation services available. Compile a list of mediator names, talk to the mediators, determine the cost, evaluate the information, and make your decision. People often discover that through mediation, they are able to resolve disputes that they were unable to work out on their own. They are pleased at how the process can help them reduce bitterness, come up with creative options, and develop solutions that are lasting and satisfying. Sometimes people aren't fighting over the same things. If you can identify what the real conflict is, it is a lot easier to resolve it. Mediation gives you the chance to talk about what is really important to you and a chance to listen to what is really important to the other person. Mediation is a process of broad application and hence the cornerstone of court-connected dispute resolution programs in Virginia. Many people believe that mediation should be the rule rather than the exception. That is, try mediation first.
Having administered over 5,000 cases since I went into this, it works over 80% of the time.
It takes less time, it's less expensive, and it's a more friendly method.
I see mediation as the thing of the future. I really do.
Mediation is definitely the wave of the future. It's already here, but people are using it for more and more diverse things all the time. That's what I see mediation doing in the future, is being something that people turn to first.
Your attorney may be able to recommend a mediator who is appropriate for your case. Your community may have a community mediation center. Or a private mediator or mediation company may best suit your needs. If the court in your area has an alternative dispute resolution specialist or coordinator, they can also help you with mediation services. For further information on mediation or mediators, take advantage of the following resources.